All right. The court will call the case of the state of Michigan versus Eric Martin, case number 23S00425.
Rachel McDuffie for the people.
And standby counsel, Assistant Public Defender Jay Bellinger for Mr. Eric Martin, who appears via Zoom. Mr. Martin, can you please unmute and state your name for the record?
I'm a living man, capital E, lowercase R-I-C, of the capital M, lowercase A-R-T-I-N family. One of the people, sovereign, not a legal fiction corporate entity defendant with a name similar to mine. I'm here by special appearance to threaten duress, not willingly. Now, again, I object again to any attorney being appointed to me, representing me. But that's something I want to ask you, Washington. Now, you said you're appointing this public defender. Are you appointing it for me, or are you appointing it for you? Or is it
Sir,
just standby?
made my decision on that. It's standby counsel. If you have motions to make, you need to make those at this time.
Yeah, that's I need. I'm seeking clarification. Are you appointing him against my will to have an attorney appointed for me?
Yes, it's not representing you. He's standby counsel. Please make your motions.
Yeah, that's it. Well, that's I was going to make the motion to dismiss him if he's if you're trying to appoint him for me, which, as I already said before, I will not be taking no attorneys. I'm one of the people. I'm not a defendant who's, yeah. So as I said before, so I'm not going to be accepting any attorneys. Give the presumption I'm under the jurisdiction of the court, which I'm not. As I said before,
Sir, you got 5 minutes to make your arguments, and you can spend them however you want to.
All right, yeah. Like I said before, I'm a living man. So, as the U.S. Supreme Court said in the cases I cited to you before, there's no jurisdiction over a living man. Corporations don't have jurisdiction over a living man without our consent. I don't consent, and it's also under. There's no consent under the Declaration of Independence of 1776. There's no jurisdiction over a human without their consent. So I never consented to jurisdiction, and I don't now, and I never will. Now I have some questions though for the prosecutor. That's
Sir, you don't get to ask questions. If you want to have a motion, you can make those.
Well, I object to that. That violates my right to a due process. It's relevant to a standing argument as to the prosecutor, whether they have standing or not. I think that's relevant to move forward or not. You know, there's no standing, shouldn't move forward. But so, what's your ruling on that?
Your motion is denied as to jurisdiction and standing. Now, do you have any additional motions?
I object to that because you didn't allow me to answer the questions to see whether you had a legit basis to make that ruling.
Your objection is noted. Next. Sorry, what?
You said you're going to be addressing some demands for dismissal I made or sent to you already. You're going to
First of all, a demand is not a proper format before a court and could be dismissed outright. However, I'm going to allow you to make your motions here. If you want to make an argument, you can do that, sir.
I object to that. That's not true. As I mentioned before, demands, when someone has the right to something, that's what the terminology demand is made. And that's the only reason why I make it. Motions, even though I know that's all you see in the court rules or whatever, traditional. But that's for a request, and persons are not, or humans are not supposed to be requesting constitutional rights. Me exercising my unalienable right, human rights and constitutional rights, I'm supposed to be making demands. That's how I've been, and that's backed up by law. And that's how I've been taught. And so that's what, so it's all right and proper. Motions are requests, and the defendant makes motions also, since I'm just.
So you're about to end of your 5 minutes.
Well, I objected 5 minutes being any time limit also.
I don't care about what you're objecting to. You can make it on the record. It is noted. Now, if you have something that you want me to address, you should do that before your time is up.
Putting a limit on my First Amendment right, that's unconstitutional.
Sir, please, if you want to have something to say other than the circular talk that you're doing, you should probably do that at this time.
I didn't finish. That's why I didn't mean to. none circular. I didn't finish the first time. All right, well, that's it. As to that,
Is the court ready for the people's response run?
I don't know if he's done with his motion.
Oh, I'm sorry.
I'm trying to make,
well, the police, I wanted to question, the police officer who wrote the ticket. I have a relevant question to him as to self-incrimination, move to dismiss, the case based on that because he made me give, my ID.
Now watch closely. This is where the defendant shifts from declarations to demands. He interrupts, objects, and insists the court follow his rules, but the judge quickly asserts control. He then pivots to a bold claim about IDs and self-incrimination, trying to twist basic procedures into violations of his rights. The back and forth gets sharp, with every objection raising the stakes and every rebuttal from the judge making it clear who really runs his courtroom.
But my memory was I don't really remember exactly what was said. That's why I kind of need to question him to refresh the memory. But I do remember in general, though, he kind of, I'm required to give my ID if I remember right, and I might have been arrested if I didn't give my ID, which was under threat and duress. And even if he didn't say that, which I don't remember, which, like I said, I need to have his body cam and all that. I want to be able to review that now, and also for the trial, if this goes to trial, I want the video present as part of my due process right for the evidence, which is my due process right, like I'm saying. And because, like I said, it violates my self-incrimination, all right, that I'm being made to give my supposed name, government name anyways, which ain't really my name, but a government name has been given. Violates self-incrimination. And then it's used against me to prosecute. So it violates self-incrimination. Yeah. Move to dismiss based on that too. And like I said, if you need more evidence as to, like I said, his questions, then he needs to answer my question. I was about to send out interrogatories to him. I'm about to do it here soon. If you find that's necessary, unless you find it ain't necessary, I'm gonna send it out soon. So, another thing. Now, Mrs. Washington, I just filed a federal civil lawsuit on you, for violating my constitutional rights during this case. So you may want to consider recusing yourself. I know you probably didn't get a receipt yet because I just sent it out like 2 days ago. So the court will be getting it, if they didn't get it already, be getting it this week. And yeah, so I want that out.
as to your motion to recuse, that is denied.
This part is a turning point. The defendant presses on body cam evidence, claims his rights are being trampled, and suddenly drops a bombshell. He's filed a lawsuit against the very judge presiding over him. With complete confidence, he demands a recusal. But the judge wastes no time dismantling that attempt, calmly denying a motion and keeping the case moving. It's a masterclass in how quickly sovereign tactics unravel when tested against actual law.
Conflict of interest is my reason. That's why I didn't mention that, but I thought you might kind of already figure that. But conflict of interest due to the lawsuit being filed. That's the grounds of my demand for dismissal.
Okay.
And I would like to, Ms. Duffy, as the prosecutor, I'd like to notify you, of the crimes being committed against me by the police officer, in this case, writing the tickets, and I request you prosecute them for this because I'm the crime victim here in reality. Because I was traveling by right, which the U.S. Supreme Court said we have, as long as you're not carrying passengers property for profit, you're not technically driving a motor vehicle. Therefore, all these charges are baseless. There's no case here. So in reality, I was harassed, retaliated against for exercising my right to travel on my motorcycle, and then with these charges. Okay, so because they had no evidence that I was carrying passenger property for profit, which is what's required. That's the definition of a motor vehicle under 18 USC section 31 subsection 6 and 10. That's when a motor vehicle is a motor vehicle. In contrast to the state law, I know what the state law says. The state law just says, oh, if something's mechanically drawn, it's a motor vehicle. Well, the state statute is in violation of this federal statute. Therefore, it's unconstitutional. Okay. And therefore, the federal statute definition of motor vehicle applies here. It overrides the state statute under Article 6 of the U.S. Constitution. Laws of the United States is supreme over state law. So therefore, I wasn't doing anything wrong. I was traveling by right on my motorcycle, as I have a right to do, without a license, without registration, without insurance.
Here comes one of the sovereign citizen classics, the so-called right to travel. He argues that licenses, registrations, and insurance are unconstitutional burdens, pulling random statutes and insisting federal law is on his side. What he fails to see is how directly his own words undercut his case. Instead of freedom, it's an admission of guilt hiding in plain sight. The suspense here isn't if he's wrong. It's how long the court will let him talk.
Within my right under that federal statute and the U.S. Supreme Court case law that I cited already in the court that they sent back. But one of the main cases here is Packard versus Banton, U.S. Supreme Court case law. Okay, this is a little more specific than just saying people have a right to travel. It mentions it specifically, and I'm gonna mention right here, Volume 44, Supreme Court Reporter, page 259. The streets belong to the public and are primarily for the use of the public in the ordinary way. Their use for the purposes of gain is special and extraordinary, and generally at least may be prohibited or conditioned as the legislator deems proper. So as they're saying right there, so we do not need a license if we're not using the streets for profit, for gain. I wasn't doing that. The police don't have no evidence of that. So he shouldn't even pull me over, stopped and wrote a ticket. None of that. So I'm the crime victim. I request you prosecute him for that. And it's also federal crime, which I'm going to be contacting the FBI about. I already tried once. I got to call him back.
All right, guys, buckle in. This is his longest rant yet. The defendant tries to bolster his argument with misquoted Supreme Court cases and sweeping declarations about state law. He even goes after the court's ban on recording, insisting it violates the Constitution. But the judge doesn't flinch, reminding him the same rules apply whether in person or virtual. Each word he piles on only digs him deeper, showing the gap between theory and reality in real time.
Well, I'm going to see if you got my, I would like to just reiterate my, the demands for dismissal already made, or if you want to call them motions, but like I said, I like using the word demand because I don't agree to no unlawful presumptions that, because I understand the legalese a little bit where you say one word and it means something else and it's presumed. And that's why I demand also that there be no legalese used in no stages of this case, because that's one of the fraudulent things going on in the court system. I'm going to be filing a class action to stop this on a grand scale, but I know it's happening. That's why, like, for example, I use the word demand to use the word motion, and it can be presumed you're a defendant. Because defendants make motions, see? So that's why there should be no legalese used here. It's fraudulent, it's wrong, it's immoral, it's pathetic. Whoever made this stuff, because it's putting it's a blanket on a lot of people that don't know no better in the system. Something else. Now, when this proceeding started, I noticed on the screen it said no recordings are allowed. Okay, now I object to that, in that violates my due process right to preserve evidence, me or anyone else, and I'm not just speaking for me, I speak for everyone else. All the people have a right to record in any public court. This is all public. U.S. Supreme Court already said this. People have the First Amendment right to record in public anywhere. And it's also a due process right to preserve evidence. Because if my rights are violated during these proceedings or any other, along with anyone else's, we have the right to record that and have that evidence to bring criminal or civil charges. So that's why that's not supposed to be popping up on the screen, that video, audio record.
Now the spotlight shifts and it's the prosecutor's turn. She wastes no time dismantling his arguments point by point, exposing how his supposed case law doesn't exist anywhere outside of sovereign copy-paste templates. With precision, she reveals how easily their tactics crumble under scrutiny. This is a sharp contrast. While he thrives on rhetoric, the prosecutor deals in facts, and that's where his entire foundation starts collapsing before our eyes.
Thank you, Your Honor. So I am aware of 5 items that have been filed by Mr. Martin, I think after this case began to be pending in this court. And I'll just briefly address the as to the formatting of those. I did notice all of them are handwritten. He does write a date on the top of each document, but then he usually signs off with a different date on the bottom of the document. So if it ever comes into play that there's an issue with the timing with respect to deadlines or anything like that, for my purposes, I'm just going by the date that it was received by the court, which is usually a third date that is different from the other 2. So the first document I'm aware of is titled Demand for the Return of My Motorcycle. That one was received by the court July 27th, or yes, I believe somewhere around there. I'm sorry, I'm not going to the dates aren't really important, so I'm not going to dwell on those. I'm just addressing these versus actually, I think, responding to them in detail. Defendants specifically ordered and demanded that the troopers from Michigan State Police return his motorcycle in this case. That is a request to police that was filed with the court. No response appears to be required or called for from the people, so I don't have anything to say about that. Next is the motion that was filed for the disqualification of the judge in this case. And I just wanted to point out a couple things. First and foremost, as Mr. Martin pointed out, the court rule that relates to disqualification of judges, MCR 2.003, speaks to the exact procedure for that. In a single judge court, and actually the challenge judge here is the chief judge, the challenge judge is the person who decides this motion. So I don't have any argument to make as far as that, but I would point out there is a quote included in that particular motion that challenges this court's jurisdiction. And it cites a case from, what's that? Oh, yes. Penhallow versus Domes Administrators. That's a case from 1795. And the specific quote that was cited in that case to challenge this court's jurisdiction, it's a paragraph or so. It begins with something about, heavens, let me see. I want to make sure I have it correctly. It's not really important. In as much as every government is an artificial person, a creature of the mind only, all that stuff about artificial persons. I think Mr. Martin already made some references to that. I just want to make sure that Mr. Martin is aware that specific quote does not exist in that case